everyone, and welcome back to the Swing State. The Supreme Court just wrapped up one of the most consequential weeks in years. In the span of just 6 days, the court reshaped presidential power, reaffirmed birthright citizenship, weighed in on mail-in voting, ruled on transgender athletes, and cleared the way for the end of legal protections for hundreds of thousands of immigrants. And here's the part that surprised me. If you only read the headlines, you'd probably think that this was a court that simply handed Donald Trump everything he wanted. That's not actually what happened. Trump lost on birthright citizenship, he lost on mail-in voting, but he won on expanding presidential control over independent agencies, he won on transgender sports bans, and he won on ending temporary protected status for hundreds of thousands of immigrants. So the real story isn't that this court is always siding with Trump. It's that when the court does side with him, it fundamentally changes how government works. Today, we're breaking down the biggest decisions, explaining what they actually say, giving the context for the strongest arguments from both sides, and talking about what these rulings mean, not just for the next election, but for the future of the presidency, civil rights, and the Constitution itself. The first case we're going to be talking about is probably the biggest surprise of the term: Trump v. Barbara, the birthright citizenship case. This was one of the president's biggest campaign promises. On his very first day back in office, he signed an executive order attempting to end automatic birthright citizenship for children born in the United States, unless at least one parent was a U.S. citizen or a lawful permanent resident. The administration argued that the 14th Amendment's phrase, subject to the jurisdiction thereof, doesn't automatically include people who are here unlawfully or temporarily. Every lower court blocked the order, and the Supreme Court took the case on an expedited basis. Then, in a 6-3 decision, the court struck the order down. Now that headline is true, but it doesn't tell the whole story. So let's break down what the court actually said and why this decision may not be settled as it first appears. Eric, Adarsh, what stood out to you most about the court's reasoning?
Yeah, so, for me, before we talk about the court's reasoning, I was of the opinion this was not going to go the way that the Trump administration wanted it. To me, just reading the whole text of the 14th Amendment, right, conservatives believe in what we call originalism, which is you read the words of the Constitution at the time they were written, interpret them based off of the historical context at the time. This is really to counter what I believe liberal justices do, which is considered to be judicial activism. You kind of read into it and kind of based off the outcome that you want at the time, you can kind of stretch the meaning of the text. So for me, right, it's very, very clear based off of the history of this country, right? Jurisdiction of traditionally means you're born in the soil. This is what Roberts outlines in his opinion. He's joined by Amy Coney Barrett. Kavanaugh reaches the same conclusion, but it's interesting because he actually has a concurrence that says we don't actually need to rule on the constitutionality of subject to the jurisdiction of. You can actually just read into the federal statute, which replicates the 14th Amendment, and basically say, well, the executive order, it counteracts the federal statute. We don't really need to talk about the Constitution. So he kind of wants to avoid the constitutional question. Like I said, Roberts and Barrett and the liberal justices ignore that and are basically saying, no, it's precedent that if you're born on the soil, you are a U.S. citizen. Look, I know a lot of conservatives are really, really upset with Roberts, really, really upset with Barrett in particular. I actually am not going to give them a lot of crap for this because, there is historical precedent of the Supreme Court ruling that if you were born on the soil, you are entitled to the full protection and rights of being a U.S. citizen. Clarence Thomas wrote the dissent, Clarence Thomas and Alito, joined together with dissent with Neil Gorsuch, and they basically said, no, that's just not enough. You basically have full political allegiance to the United States for you to be considered to be under the jurisdiction of. And basically that's instead of just being born here, maybe a parent needs to have full domicility. They need to actually reside in the country. And that's a way more narrow view of the 14th Amendment and what it meant at the time. And Clarence Thomas basically said, look, the 14th Amendment is to basically end the slavery question, reinvigorate the country, bring everyone together. This is not supposed to be where an illegal immigrant can come over the southern border, have a child, and that child is entitled to the protections of being a U.S. citizen. While I agree with that policy in theory, I don't think it's the judiciary's, role to decide that because of how the 14th Amendment is written. You could say at the time, why didn't they just write that into the 14th Amendment? And I agree. Why didn't they? You can kind of argue that it's implied that it's, assumed to be, but, if we're going to be originalists, we can't really just assume any of this. So I believe you really need a constitutional amendment to fix that problem. I think Congress should do its duty and pass a constitutional amendment. And I'm not going to give Barrett and Roberts crap for sticking to a very, very traditional originalist argument here. So that's kind of how I feel about it. I obviously don't agree with that incentive in theory, but I don't think it's up to the judiciary. I think it's up to the legislature if they want to fix that. Darsh, I don't know if you agree with me or you're taking a little more narrow view like Clarence Thomas did in his dissent.
No, I mean, I think generally speaking, right, like if you're going to be talking about what the point of the court is, right, is to basically see, if this wasn't President Trump and if this was a different president, right, like how would these powers also feel to them, right? And I think you have to kind of take that approach too. And so obviously taking that understanding, like I understand why this was struck down in the courts. I just think that, what is the most important thing here is I think how we kind of move forward from this, right? And I think you see kind of the path forward is really just to be able to go through like a constitutional amendment or some sort of congressional, act that's, brought forward. And I think one of the things that was interesting to me that I think Justice Alito touched on was the old Civil Rights Act of 1866. I think the language there was talking about how citizenship would be given to those who are not subject to any foreign power, which is obviously like kind of a narrower and more sovereignty heavy phrasing than what actually ended up in the final citizenship clause, like in the 14th Amendment. But I do think that taps into like a very basic intuition, right? If someone is here illegally, they're still anchored in law and loyalty to another sovereign country. And so I think even if you don't buy into the full legal reading, like that concern is definitely real. But I think the path forward here is also pretty clear, right? Like you have to accept the fact that the courts have reaffirmed this core birthright rule and you have to move to fight where it actually belongs, right? Like you have to start looking at visa policies, cracking down on birth tourism networks, asylum abuse. If that's happening, that also needs to be fixed. And so I think the battleground now is really like enforcing and trying to close all these loopholes and not really trying to override this with any sort of executive order that way, because I think that just has clearly like not worked. And I think we've talked about this in the past too. Like I agree with a lot of what President Trump is doing, but I guess this approach is just not going to work. And so the one thing that I also think is interesting is I think there was an act maybe back in like 2024. I think it was called a Constitutional Citizenship Clarification Act. And that is, I think, a great avenue that should be maybe like thought about by Republicans now to try to kind of bring this conversation back, through Congress.
I think just one more thing I want to mention is, for those of you that didn't read, Robert's opinion, he also very much relies on precedent. And this question was kind of already decided back with Wong Kim Ark versus United States. And basically that was a child of two Chinese nationals who was born in the US. His parents aren't citizens. Is he a US citizen? And the Supreme Court said, 7-2 ruling, yes, he is. So it's kind of already been established. Robert wants to rely on precedent. It's funny because in Clarence Thomas's dissent, he actually specifically mentions this Supreme Court case and is basically saying, well, one of the parents had full domicility and, basically, even if that wasn't true, we are willing to kind of throw that aside. If there's a bad precedent, no matter how long it stands, some members of the court are willing to, throw that aside. We're actually going to see that in another case coming up, but there is precedent, and if Roberts is writing the opinion, he's really not going to tend to want to upheave strong constitutional questions that have kind of already been answered by the court. So, like I said, to all the activists, I would also be upset on the outcome, as in we really don't want to have illegal immigrants just coming over and having children just for the sake of that, but again, we have to remember that the judiciary is, not always there to just kind of wave a magic wand and fix the problem, right? I actually think that would be bad for a lot of policies if we let the left do that as well. So we want to keep the judiciary in its lane. Like I said, I'm not going to give Amy Coney Barrett and Roberts a lot of flack for that because I think it's a true textualist reading, and that's kind of what I support as far as how to interpret the Constitution. So, but I don't know if you have any prevailing thoughts as well on this one.
Yeah, no, I think what you said is accurate. I think that the biggest thing from my perspective here is Kavanaugh's perspective on this, and that it's not that you can rule it based off of a statutory argument and not necessarily constitutional grounds. I think that's going to be something that everybody needs to watch out for because it's how you can, I mean, at the end of the day, that then converts this from a 6-3 vote to a 5-4 vote. And, if the Chief Justice wasn't there, it could swing the other way, and like, so the question here is like, I think there's a lot more concern and there's a lot more, like you said, completely support the fact that right now in the Constitution, the way it's written and how it's being read, and based off of precedent that exists, birthright citizenship should stay completely legal. But, there are other ways around it, such as, having Congress create pathways to kind of minimize what birthright citizenship looks like for whom. And I think that that's something that is potentially a pathway that Republicans are going to take in the future. And it's something that people need to be mindful about.
I think that's the
Yeah, but
preferred
I mean,
way.
I think, yeah, and I think it also would help clear up, right? Like, I think you mentioned this too, like the whole argument has always been about what is subject to the jurisdiction of like really mean. And so if Congress is really able to like codify what that means and like write it down, I think that would really help. And so I think making that a little bit more clear in Congress, I think hopefully maybe we see that happen. It's funny. I think the act that I mentioned before, I was just looking into it. I think JD Vance was one of the co-sponsors of it back in the day. But even that, honestly, like I think would be a great option, right? Because I think just to kind of give context on what that specified, I think it was like if you're a child of a parent who's here unlawfully or like on a diplomatic mission, or if you're like engaged in hostile activities against the US, you wouldn't just be granted citizenship. And so I think that kind of helps at least give that some clarity. So hopefully we see some actual things happen in Congress versus like, just yammering, but we'll see how that goes.
Yeah, I mean, if people are going to complain about that, like, just you need to do a better job of campaigning for members of Congress who are going to do the things that you want that are high priorities for conservatives. This is one of the high priorities to start campaigning. We cannot just rely on the judiciary to swing the magic wand because that's not a precedent I want to set. That's not what I think the judiciary is there for. So yeah, the legislature, which is for the most part kind of just been, in my opinion, sidebarred by the executive and the judiciary. So, but again, I'm not going to get too much into that.
100% agree with that. Maybe not for the same reasons, but I agree with that for sure.
Not for the same reasons,
All right.
but it's still the same result, right?
Yeah. So that's one of the two major cases this term where the court told President Trump no. And I actually think that's what makes the next case so interesting as well. Because if the first case was about the limits of presidential power, this one is about elections. And once again, the court surprised a lot of people. The second case is Watson v. Republican National Committee, a challenge to Mississippi's mail-in voting law. The question was straightforward. If a ballot is postmarked by Election Day but arrives a few days later, should it still count? Republicans argued no, Mississippi argued yes. In another unexpected ruling, the Supreme Court sided with Mississippi in a 5-4 decision, holding that federal law sets the deadline for when a voter has to cast their ballot, not necessarily when election officials have to receive it. So let's unpack why the court came down to that decision in that way and what it could mean for the future of mail-in voting. Thoughts?
For this one, I was surprised. Okay, I thought, you know what, there is no shot that this court is going to allow grace periods for mail-in voting because this is again a huge conservative priority, which is we need to stop this universal mail-in voting. And one of the ways to do that is ending grace periods. So I was shocked at the forefront. I actually sat down, I read Amy Coney Barrett's decision. And again, a lot of people were upset with Amy Coney Barrett. But I'm just telling you, if you read it, it's actually pretty good. And I actually agree with her reasoning, right? Because again, this theme of we want the judiciary to just do whatever we want when all other options are exhausted, or I wouldn't even say exhausted, just we haven't even tried hard enough to get all the other, branches to do what the conservatives want. It's like, no, we just need Amy Coney Barrett to get on our side. It's like, no, let's actually read what this federal statute says, right? And so her main argument is basically this. There is, a national deadline for elections. That's Election Day. There is a difference between casting your ballot and receiving your ballot. And federal law makes it very clear that those things are separate. Now, the dissent written by Alito says, well, actually, casting your ballot and receiving the ballot, that needs to happen at the same time or by the same deadline, which is Election Day. And Amy Coney Barrett says, well, actually, the federal law does not actually explicitly mention receiving your ballot. And there is federal law that does actually clarify receiving and casting. So if the federal government, if the Congress actually wanted to distinguish between the two, they have and they could have. but they didn't in the laws that were challenged by the Republican National Committee. So because if they're clearly, separated, we cannot assume that the Congress or federal law expressly prohibits Mississippi from having a grace period. And when I'm reading, I'm like, you know what? That's actually kind of fair, right? We can't just read into this and be like, yeah, let's just assume that they meant it's the same. So therefore, let's just throw it out, right? It's like, no, again, Congress has the power to regulate elections in this manner. If we want to stop, or at least prevent unlimited mail-in voting or grace periods, get Congress to act. Again, I'm not going to criticize Amy Coney Barrett for having a very, very strong textualist reading of federal law here. And so, again, while I agree with a lot of the Republicans who gave her crap that we need to kind of mitigate grace periods in mail-in voting, going through the judiciary is not one of the ways to do that, especially when federal law has distinguished between the two. So, again, I was surprised, but after actually reading it, it makes a lot of sense to me. And again, it's just let's lobby Congress to actually get some national legislation passed on regulating that aspect of elections. So, but I don't know if you agree with me on that one too.
No, I mean, to be honest, like I will say the one thing that I read that honestly from Barrett that kind of convinced me a little bit too was I think she said that I think talked a little bit about how basically if there was a federal law that kind of imposed like a hard nationwide like deadline for receiving ballots, then there would really be no reason for Congress to defer to state receipt rules. And I think like that from like a state rights perspective makes sense to me. You know what I mean? So I think that when that rationale I think made a lot of sense from her. Now, I think that it's just a little tough when you're comparing it to like what we should actually want happening, right? And I think that just goes back to what you were saying and that we need to be proactive in Congress. And I think that's just really what it comes down to because you can't it's really coming down to this point where like, yeah, the courts are not just going to do something just because we haven't really tried to do it another way. And I also think the other, piece of this is too, we have to also just be thinking about reform that makes cheating harder. And I think it's kind of what you said, Eric, is in I think a previous episode is let's focus on getting that done rather than crying cheating and crying scandal and doing that, because I think ultimately that's the best way for us to move forward here because the courts have already spoken here, right? And at this point, it is what it is, and you just have to move forward from that.
I mean, are we really going to get mad at Amy Coney Barrett for having, a narrow view of federal law and what is essentially empowering the state over the federal government? I thought that was a huge factor amongst conservatism.
Yeah.
It's like, guys, why are we getting mad at
that's
her
what convinced me, honestly. Her framing it that way is what honestly made me a little bit more understanding to her rationale there.
But yeah, it's like everyone's like, oh my God, Amy Coney Barrett is like a liberal in disguise. It's like, guys, she overturned Roe v. Wade. She literally wrote the opinion of Trump v. Casa, which limited universal nationwide injunctions of the judiciary. And she basically voted to give the president unlimited immunity from official acts as president if they're criminally related. Yeah, like what are we saying? Like she's a liberal disguise. It's insane. She's having a very narrow view of federal law, and if you read it, it makes a lot of sense. So how about instead of crapping on Amy Coney Barrett, you crap on your representatives, your senators for not passing nationwide election legislation like the SAVE Act, as we touched on the previous episode. So again, it's just like it's such selective outrage. It just is pretty annoying for the most part, and it's like
classic Republicans, though. Am I right?
Well, I'm not a Republican hack, so I'm going to tell you when they're doing something that I strongly disagree with. So, at least
it's
me,
okay.
you don't have to question my integrity.
Just hear the party line from Mr. Venkat.
Oh, perfect. Yeah.
But no, I agree. I think that this is another example of, federal law being specific enough and the judiciary being strong and thinking through things a little bit more rationally, which is nice to see. And I think that, you said it, like many people have been crying wolf and trying to find any ways possible to get past certain laws, certain regulations. And the judiciary in this case kind of stood their ground. And like you said, they're not the right way to kind of get this done. The right way to get this done, if you believe that that's the case, is to go through Congress and make sure that Congress makes laws that are, recognized across the country and that align to whatever we believe as a country is a definition of cast versus receive, and where that line stands and when it comes to election day.
Yeah, I think specifically brings up in the opinion, it's the National Uniform and Overseas Voting Act, and that act specifically does distinguish between casting and receiving. So like I said, if you actually want to go look at specific laws and statutes that do reference to difference, it's like there is an example. Like this isn't just like random code in the books that you might find that they distinguish. Like no, they do distinguish them. But I want to be clear. I mean, at least Vita Darsh, if I can speak for you, we want, Alito's outcome though. Like I definitely want to limit the grace period and mail-in voting. But again, it's not up to the judiciary here to do that in this very, very narrow sense. So yes, I don't want anyone to get it twisted that I actually for some reason don't want that. I think that would be good to limit the grace periods. And I've like, for example, California is like 10 days. I think it's soon to be 14. So yeah, again, not the judiciary's responsibility.
Yeah, I think we talked about this too. Like, I agree with that 100%. I think the biggest thing is like a lot of these policies, even if, you say that there is 100% no cheating, I think they are policies that invite cutting corners. And I think if you design a system where, a large number of ballots are floating around in the mail and can still show up days later, you've made it easier for bad actors to try to exploit weak links. And I think from a policy perspective, you shouldn't want to wait for a full-blown scandal and then react. You should try to be proactive and build rules that like minimize both actual cheating and this perception that cheating is even possible. And so I think that's kind of what we should be thinking about as Republicans moving forward, and hopefully we can get there.
Yep, agreed.
Disagree fundamentally, but we can move on. Okay, so the next case shifts from elections to presidential power. Earlier this year, President Trump fired 2 Democratic commissioners on the Federal Trade Commission, arguing that if they're part of the executive branch, the president should be able to remove them whenever he wants. The commissioners sued, pointing to a Supreme Court precedent from 1935 that said Congress should protect leaders of independent agencies from being fired without cause. The question before the court was whether that 90-year-old precedent should still stand. In a 6-3 decision in Trump v. Slaughter, the court said it shouldn't. The justices overruled that precedent and held that the president generally has the authority to remove heads of independent executive agencies. But on that very same day, the court also decided Trump v. Cook, temporarily blocking President Trump from removing the Federal Reserve Governor, Lisa Cook. So why did the court say that the FTC isn't independent enough to be protected, but the Federal Reserve is? And what does that tell us about how the court views presidential power going forward? Eric?
Yeah, so for this one, it's funny because Roberts, in his opinion for Trump v. Cook, which is the Federal Reserve case, his line is that he acknowledges the unique and independent role that the Federal Reserve has on the nation's monetary policy and the banking system. And basically, based off that logic, that means that in this very specific circumstance, the administration is not able to fire Cook right off the bat. They actually don't like. They basically say you can't fire her immediately. You need to let her respond to your firing her. And this is, I believe, it's the mortgage fraud stuff. So
Yeah.
it's like we need time to kind of, address that. Look, I actually don't agree with Roberts here. I think that you need to just, if you're going to get rid of Humphrey's executor versus U.S. precedent, which is that's the FDR case that you mentioned, Armand, where basically the Supreme Court unanimously ruled against FDR. And it's funny because these are Republicans at the time ruling against FDR that basically say you cannot unilaterally remove heads of some of these executive agencies that are considered to be quasi-legislative and quasi-judiciary. Basically says Congress can impose some restrictions there. It's ironic now that conservatives are removing a conservative case that was meant to limit a Democratic president. I just think it's funny and ironic. But fundamentally, I agree with Trump v. Slaughter because, look, I think that if you're going to have an executive agency, it needs to be accountable to the president, and therefore the president is accountable to the people. You cannot just have these, everyone like say these unelected bureaucrats running these agencies. You need to have them accountable to the president. And so for me, I'm thinking, if I elect the president, I want him to enact and execute laws in certain ways, regulations in certain ways. And to do that, I need to be able to fire the heads of these agencies who are overseeing the implementation of my domestic policy. And I don't need a reason other than they don't align with my policy to do that. And so I'm actually completely fine with that. I don't think Humphrey's executor set a good precedent. And I think that should be carried over to Trump v. Cook. I don't think the Federal Reserve in particular needs to be like siloed from this. I think that's kind of like a weird cop out. I don't think the logic really follows just because they've been, necessary to the banking system. I mean, they've only been like since what, 1913. So, I mean, the grand scheme of things, not entirely too long. So I agree with Trump v. Slaughter, don't agree with Trump v. Cook. I think if you're just going to just carve it out, just carve it out. You don't need to be making exceptions for the Fed. But that is more nuanced. I don't know if you guys agree with that.
Yeah. So, I mean, I don't think I necessarily agree with that 100%. I think you kind of, you touched on it right. I think one of the things that at least I feel, and I feel like a lot of conservatives feel, is if we elect a president to run the branch, like we want him or her to have real authority over the people inside it. So when Trump wants to remove these people, there's like a very natural reaction that's like, yes. But I think when you kind of start to look at the structure, like it kind of makes sense why the court is drawing some lines. Like if you take a look at the Fed, there's a real reason why these governors have fixed terms and they have these like for cause protections. And I think if a president can remove any of these people at any time, there is a significant policy clash that risks turning monetary policy into like daily partisan combat that I just don't think should exist. Markets don't like that. Borrowers don't like that. Investors don't like that. And I just think that's a bad signal to be sending. But with agencies like the FTC, right, I think it gets a little bit murkier. I think those agencies are a lot more, they're closer to like classic enforcement bodies. Their job is to kind of go out there and do that. And so I think there's a stronger case there to be made that the president needs more direct control over those people who are effectively kind of making national economic policy, not really like monetary policy, if that makes sense. And so I think that's kind of where I stand. And I think that, I think I mentioned this earlier too, like we should be honest to the fact that like any expansion of this power removal that we're talking about today and that we're happy about today is also going to be available to the next Democratic president too, right? I mean, you brought up FDR, like it's the same concept, right? It's like a similar thing. So like, I think, yes, we need to rein in, unaccountable regulators, but also be careful about erasing all independence, especially at the place like the Fed. Like I do think there is value to having a certain level of independence. And I think that's why I think that this argument kind of makes sense here.
My take is pretty much these agencies that we're discussing right now, the FTC, the Fed, the SEC, all of these agencies, nuclear, regulatory commission, were all made as bipartisan agencies, and they're different than the Justice Department or other enforcement arms of our government. And I think there's a reason for that, because the enforcement arms of our government are fully controllable by the executive branch. These specific agencies that are meant for bipartisan, non-specific for, daily, like you said, daily partisan combat should not be allowed to be completely fireable by Trump or by whoever the president may be. I think it's important for us to have the discrepancy or that distance between these agencies' leadership and Trump and the president. Now, I do think obviously there are potentially more guardrails that can be put into place, to ensure that the president has some level of say in the general direction of monetary policy or in the general direction of whatever policy that we may be discussing for these agencies. However, I think that just that separation allows for not focusing on anything related to politics in the day and the time, rather than just having it be another card that these politicians can use during campaigns, etc. And I think that's why the Supreme Court is able to do the decisions they're able to make, is because of that separation, and that same separation was the purpose of these different agencies that were created.
Yeah, but in your circumstance, there is no accountability really. Like we can call it bipartisan and basically say, well, it's the experts, so they're kind of above the fray. But it's like, no, they need to be accountable to the president. If you cannot fire them,
why?
Because
Why
you
do
want
they need to be accountable
want
to the
the
president?
people in your government to be accountable to the people that elected them, and that chain
Why are they not
chain
accountable
flows
to
from the president
Congress?
to him.
Why are they not accountable to Congress?
No, the heads are not accountable to Congress because they're under the executive.
Right, but Congress created these as bipartisan agencies. They created these as agencies that are supposed to be separate from complete control of the executive
Right.
for that
Right. I'm
reason.
saying that's a problem because that means there's less political accountability. You want the president, you want some elected member to have complete to have accountability of these people. And if I'm electing the president and I want them to have a certain domestic policy and agenda, that means I need to be able to fire you for things other than just, negligence or malfeasance. I need to be able to fire you because you don't agree fundamentally with what my domestic policy agenda is going to be. So I disagree with the
But
precedent that was set in Humphrey's executive of, no, we need to have these be independent because some things are just, above politics. It's like, no, I don't even agree with that. There's no such thing of like these independent agencies. You're just obfuscating, being not accountable as independents. I don't agree with that. So I'm fine with the Democrat, being able to do that, right? They're elected. That's their prerogative. Do what you will. But I don't think this like independent quasi, legislative body that is somehow insulated is good for the federal government. I want them to be accountable to the executive branch.
I mean, I think there's a difference between the Fed and the FTC though, because I think the Fed is more like they're more like enacting policies, but the FTC is like they investigate companies, they issue subpoenas, they're like pure more so an enforcement agency, which is why I think I more so agree with the way that the courts decided on both of these, is because I think if you're enforcing the law, then you need to be under, you need to have be under the president's jurisdiction. That just makes perfect sense. But I think the Fed has to be acting as a little bit more of an independent body, because that's what the purpose of it was, is to create it independent of the government so that it can, help the markets and help the economy that way. So I think it's purely like an enforcement versus like policy kind of differentiation, which is what makes me comfortable with these decisions.
I think it goes back to what you guys said about mail-in voting. Both agencies were made for the purpose of being separated. And so if you want to change that, you go through the legislative branch and you change it in that way. You don't change it through the judiciary, because this is just a reading of the law that's like now kind of arbitrary and not, focused on what was actually truly meant to be. And everybody can agree upon what was truly meant to be. Even the justices can, that in that, like, it was truly meant to be an independent agency. And now the question is, should you, as an agency under the executive branch, right, have control, be under the control of an elected official, like you said, Eric, or not? But I think the answer to that question should not come from the judiciary. It should come from the legislative branch. And I agree with you, Adarsh, that especially the Fed should definitely stay separated from the executive, because we know so now more than ever, any word that the president says completely affects the way the world reacts to the markets, to everything, right? And now if you add on another layer of, now he has control, he could have had a control of our actual monetary policy, that completely changes the game. So that separation is very, very important long term. I also think so, though, across the board for these different agencies, because they should be separated from, they are working on things that are outside of partisanship, and by bringing them in, you're creating more reason to increase hatred from both sides about what these agencies do. Like, one side's going to be more anti the FTC versus the other. One side's going to be more anti the Nuclear Regulatory Commission than the other. And that's just going to create more separation and divide in the country that might not necessarily even be needed.
Yeah, I mean, I think though, like for example, like the Fed, like all of their policies too, they need to be thought about from a very long-term perspective. So they need to be like, you can't just be like, okay, we have, let's say, 8 years of a Republican and 8 years of a Democrat. It can't just be, the policies can't just be focused on 8 years and 8 years. It needs to be focused on a larger, looking period. Now for enforcement though, like I think that always changes with every administration, right? Which is why I think having that flexibility to be able to, get rid of these heads of agencies and those enforcement agencies makes perfect sense to me. But yeah, I think I think the independence of the Fed is crucially important.
Yeah, I kind of like I actually get what you guys are saying with the Fed. I don't hate that argument. I just think, it is arbitrary, I feel like, with the Fed, because it's like, who's to say for the FTC, right? Pursuing certain antitrust cases isn't important enough to be insulated from complete, firing by the executive at will. right? Like that's a huge component, right? Maybe one
Mhm.
administration wants to enforce, canceling out certain mergers and acquisitions that are up to a certain dollar amount or a certain size of company, right? Versus another president is a little more actually, willing to let that happen. So for me, it just seems arbitrary because, like I said, who's to say that's not as important enough to be covered? So for me, I just want the logic to flow, completely. I do, to be fair, agree that the Fed does have more importance than the FTC on as far as general policy. But still, I think that, the president's, is elected, it has an agenda, and they should be able to fire, heads of these agencies to oversee their agenda. But I'm not in a position to really arbitrate on if the Fed is independent enough. But I guess, you guys agree that they are. So, which is fine because they are super important, to be fair.
Yeah.
Yeah, I think the last thing I'll say is that when you look at, these different agencies in a dream world for me, right? I think that, again, like I said before, the decision should be made, or the adjustments to the agencies, guidelines should come from the legislative branch. But I do think I don't disagree with you that some of these more enforcement focused agencies like the SEC or the FTC should have a little bit more alignment to the general policy that the executive branch wants to move forward with. And so I think that there could be a balance that is created in the way that the law is written for these different agencies, where you have somebody who can't be fired by the president, but you also have some within that 100%, mapping of what their power is. 30% of it has to be like aligned to very directly what the president wants you to do. And in that way, you're seeing, okay, hey, this 5-year term or this 6-year term person has a lot of flexibility in what they're able to do, and making sure that they're not focused on the specific politics, but they're also including what the president wants, because that is part of their mandate as well, and making sure that during each term you are aligning to what the unitary executive wants to move forward with your policy, general policy.
Yeah, I just want to mention as well, to Armand, I'm not even saying that, right, the Congress should have no like power here at all, right? For Trump v. Slaughter, she basically sued under the Administrative Protocols Act, which lines out how you're supposed to just, it's, to me, it's just like general protocols for administrative procedure for dealing with these agencies. And I'm not saying like toss that out the window, right? I'm not saying just let the president just do whatever the hell he wants with these agencies, dismantle them, and whatnot. I'm saying in this strict circumstance of leadership, which to me is important because it sets the tone and the general, precedent for how your agency is going to conduct itself during the administration.
Mhm.
I think that's important, in particular. So I just want to make it clear that I'm not saying shuck out all the protocols that Congress has set on these agencies. But for this narrow circumstance, I think it's warranted that the president should be able to fire them to set their domestic agenda.
Yeah.
Yeah.
And
I mean,
I don't know, maybe even worth adding like a secondary step, right? Like if the president wants to fire them, but then he can get like, congressional approval, maybe that could be like an easy way to get, rid of someone in the Fed. I mean, that's something that you could maybe come to support, because then you're getting at least both kind of bodies, out there. But who knows if
I
that
would
will ever
support
come
that
to
across the
existence.
board. I'd
Yeah.
for sure support that across the board.
Yeah.
The mud
There we
because
go.
because
We
that
landed
creates a
somewhere.
little bit more, it creates a little bit more check in the power, right? Like
Yeah.
it just, you need a little bit more across, but on all the agencies. It doesn't just need to be the Fed, it needs to be all of them, because I think that there is value in that checks and balances just a little bit more,
Well, I
I
think
mean,
the courts feel like it's fine right now for some of the agencies. So
the president
I
didn't
think
have
we can
enough
leave
power
that
at the
be for now.
time, so this is necessary to rebalance the scales. So
Yeah. There we
the
go.
legislature was very, very
Perfect.
powerful. So
Okay, so the next case deals with one of the biggest issues in immigration policy, temporary protected status, or TPS. The case is Mullen v. Doe. It began after the Trump administration moved to end temporary protected status for roughly 350,000 Haitians and about 6,000 Syrians, arguing that the conditions justifying those protections no longer existed. The challengers didn't just argue that the decision was wrong, they argued that federal courts should be able to review whether the administration followed the law before ending those protections. In a 6-3 decision, the Supreme Court sided with the Trump administration, holding that Congress largely barred courts from reviewing these decisions. In other words, it wasn't deciding whether ending TPS was a good policy. It was deciding who gets to make that decision. And it concluded that for the most part, it's up to the executive branch, not the courts. So with that in mind, do you think the court got the separation of powers equation right? Or do you think that this gives the executive branch too much discretion over the lives of hundreds of thousands of people?
No, I
Eric?
mean, I agree with this 100%. Again, this is another Administrative Protocols Act, right? Like you mentioned, they're sitting on whether the administration followed the necessary procedures in place set by Congress to terminate the act. I don't think that this should apply at all. So I actually, I guess I agree with the court. Um, we have to remember, right? Congress has deferred immigration policy to the executive branch, and TPS is one of those examples. If you can kind of, in my opinion, right, this was expanded under Biden, and if you can expand it, I think you should naturally be able to terminate it as well. Again, this is a program that I feel like has been, I don't want to say taken advantage of, but it's becoming more and more prevalent when it's supposed to be temporary. And a lot of like when you apply for this, you know, it's not like the problem that allowed you to be accepted in the program. Once that is done, then you must return to your home country. It's not like, well, the follow on effects make it too difficult to stay. And that's kind of what the previous administration had been saying. So I'm fine with the court handing this back to the president to just terminate it. I think that's fine. I don't really see a problem with that. And yeah, I think this program has been has overstayed its welcome.
You'll be
Yeah, and I
happy to
think
know that I agree with you.
Well,
Not on
well, I want to hear you. I
not
want to hear
on
your
what
explanation
the
then.
program is, not on whether the program itself is constitutional or not on whether or not I agree with the program, but what you said specifically, who is responsible for the immigration policy in the country. And since the legislative branch has deferred immigration policy to the executive branch, I think it is well within the executive's power to make decisions about immigration. And in this specific case, limiting or getting rid of this specific temporary protected status is fully within the executive's control. Do I support him doing this? No. But do I think he has the right to do it? Yes.
We're practically a MAGA Republican now.
Ha 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 ha.
Yeah, I mean, I don't really have anything else to add there. I feel like, it's pretty clear that Congress did give the executive the authority and the courts are just upholding that. And I think the biggest thing to kind of take away from this whole, spree of decisions is I think the Supreme Court is just saying, like, don't expect us to fix policy you don't like. If you want to fix policy, like, go to Congress. And I think hopefully they've done a good job of, telling voters that, you need to wake up and fix Congress. Otherwise, you're not going to get what you want done. And that's for both sides of the aisle. And so hopefully that gets people to go vote this midterm season.
I think we have to
Yeah.
stop
All
looking
right.
at it. Before you end, I just want to say this. Like, I think for if you're a Republican or conservative who really supports the Trump administration's policies, we have to stop analyzing the court from the perspective of, is this a win for the president, and more of, is this a win for the way that we prefer to read and interpret the Constitution and federal statute. And I think by and large, all these decisions were interpreted in ways that I actually can see a true textualist and true originalist coming to that agreement. So I feel like the theme has been, for a lot of activists on Twitter, it's been shit on Amy Coney Barrett. But I have to say, like, if you read her opinion, it makes sense. And like you said, Darsh, right, we have to start working on Congress. That's where we should be actually having this fight instead of overpowering the judiciary, because that could bite us in the long term. So I just want to make that pretty clear for people who are, at least just getting into kind of how the judiciary, interacts here, because there are a ton of major cases that could have gone differently.
Yeah,
100%.
very well said.
But before we wrap up, one last decision that's worth mentioning, even though we don't have time to dive into it. In Little v. Hecox, the Supreme Court upheld Idaho's ban on transgender athletes competing in girls' and women's sports, ruling 6-3 that the law does not violate Title IX or the Equal Protection Clause. It's one of the term's most politically charged decisions and is likely to shape similar laws across the country, but it's also a debate that extends well beyond the courtroom. One thing specifically to mention here is this specifically only refers to women or transgender women playing in women's sports. There is a much broader discussion about transgender bathrooms and IDs and everything like that. And the court specifically mentioned that none of those are getting taken into account in this. And so you'll also be happy to hear that I support this as well, only because of its narrow view in terms of women, transgender women support in playing in women's sports. I will say there's a discrimination angle here that I think that can be, talked about and deeply dived into. But I think from a fundamental perspective, from a scientific perspective, there is value in having women's sports stay in the realm of the gender that you were assigned at birth. But I'm sure you guys agree with that, and we can just move forward
Well, I agree with
with
that. I
that
just
as
want to
well.
say in Elena Kagan's dissent, she actually says that there isn't enough evidence to determine that there are differences between transgender women and, I guess, biological men, at early stages. I'm just like, what are we saying? Like, there are differences, and like you said, all the other cases, right, that's coming in the pipeline, but there are differences. And no one's saying you need to actually, you should discriminate against them in certain circumstances, but for this very narrow sense, it's like, yes, you should, keep it separate. I think that's completely reasonable. So,
Yes.
Yeah.
Well, let's just be clear. You should not discriminate against
yeah.
anybody ever.
Well, some
But
people think that you just should. It's like, no,
yeah,
no
Trump.
one's saying that.
Yeah. 100%. No, I mean, again, I think that the concept here is there's a lot more detail. There's a lot more, from a fairness perspective, I think there exists, rationale. But I think there is also there's a right way to also enforce this. And I think that's going to be what creates the discrimination or doesn't create the discrimination. And so it's about being mindful of how we enforce this, how we explain this to people, how we, move forward with this law or with this judgment and make it safe and equitable for everyone and to play the sports that they want to play in the way they want to play them.
Yeah. No, I think the one thing that I do want to talk about this one is that, like, I do think that it needs to be addressed, like, how this is going to be enforced, like you said, because I think, like, now I think it opens up this concept almost where, like, you can dispute, like, a female athlete's sex and kind of just force her into these, like, verification exams. That doesn't really exist for boys, right? And so I think being able to kind of make sure that you handle that and approach that in a fair way is probably also important.
Well,
And
I
so
think that it would be equivalent in the other way around. Like, I don't think this is not just a woman on woman thing. This is this is on both sides. The precedent will stay true.
I
You
thought you
know,
said it was specifically for women in women's sports. That's what you said.
No, so the case is based off of that, but what the differential is it's not talking about bathrooms, it's not talking about IDs. There's like other things that
No. I
transgender
get.
individuals, that's the thing. This obviously this is directly relevant to this case was about women on women, but it's
Uh-huh.
going to be directly aligned. Like no court is going to say get a case about a man and be like, "Oh no, this shouldn't apply to the men as well." It'll be
No.
even.
I know. That's not what I'm saying, but I'm just saying, like, if this is like specifically mentioned for women, right? Then I'm just saying you don't want to single out just girl sport participants in police, just them. You also want to do it on the other side too.
Yes,
Yeah.
I think that's
Yes.
very
We just admit
obvious.
you
That's
just
not
keep
something that should be
biological
said.
men and biological women in their own sports. It's not that complicated.
Yeah.
There you
I
go. And
mean,
then you can
Or
have like
create
a
a
it's
third,
transgender league if you
bit.
why
want.
don't you create a third
I
one?
just
Like
said
we
that,
can
right?
create
You
a
create a
third one.
transgender league
Yeah.
if you want to do that. There
You
you
can create
go.
it. I'm
Yeah.
totally okay with creating a third one.
There you
Yeah.
go.
That could be
Problem
fun to watch,
solved.
I
actually.
also think that we are cisgender males that are making decisions for transgender folks, and I don't know if that's acceptable either. So let's just
Got it.
be mindful of let's be mindful of who we are and what we believe in, and make sure that the people who are being decided for should be in the room when they decide things. I don't know. It's my take.
Perfect. No.
Yeah, I don't
Well,
need to be transgender to know that a biological man should not compete with a biological girl. So I think that's
yeah.
pretty common sense, regardless of what gender identity you have.
All right.
Correct. All right. With that, I think taken together, all of these cases are painting a fantastic picture of this specific Supreme Court. It wasn't a term, the 2025-2026 term, where President Trump won everything or lost everything. The court rejected him on birthright citizenship and mail in voting, like we talked about, and expanded his rights on presidential authority over independent agencies and limited judicial review of immigration decisions. and upheld state restrictions on transgender athletes. Whether you agree with these decisions or not, one thing is clear. The court continues to reshape the balance of power between the president, Congress, the states, and the courts. And those rulings are going to have consequences long after this news cycle is over or this presidency is over. With that, it was great talking to everyone this week, and see you next time.